Salutations, salutations, one and all. So welcome to this live stream. I'm Coach Tate with My Court Coach, and I'm happy to be back. Today we're going to be talking about some issues about contempt in family court in California. And this is in response to a viewer question. If you have any questions about any of the videos that we have, recommend that you add a comment to the video so that we can discuss it in a live stream or in a video. What is My Court Coach? My Court Coach is a resource for people who are representing themselves in court. At the website, you can find all sorts of information for family law cases in California, as well as any court case in any state in the country. We have a program called Full Court Preps that will help you know how to prepare and present your case in court. I want to remind you that anything we talk about today is not legal advice. I'm not your lawyer. You shouldn't take anything that's said today as advice specific for you and your situation. Instead, this is just some coaching and some things that I've seen and trying to provide some resources for you as you navigate your way through court. So with that having been said, I want to also remind you that this is a public forum. If you were to make comments or in the chat, I don't recommend that you use real names, especially names of children. Okay, so this is a question that we have on our video. When should I bring a contempt action against my ex in California family court? And the question says, if my court order says I get FaceTime at 6:30 p.m. every night with our 4-year-old, but she has missed multiple times, is that contempt? In other words, I think the ex-wife, or maybe just the ex, is saying that the 4-year-old is not available, I guess, or who knows what reason she's giving, but she's not making the 4-year-old available to do a FaceTime with dad, and dad's wondering, is this contempt? Fantastic question. Now, you'll see in our other video some forms that you're going to be using if you file a contempt case. And one of those forms is the FL411 form. And let me just share that with you real quick. The reason why I want to share this form with you is because the forms do a real good job of explaining what, giving you indications of where else you can look to find the rule that applies to that form. In other words, the law. So if we take a look at the FL411 form, which you should see on your screen now, this is an affidavit of facts constituting contempt. And if you look at the bottom right corner, you'll see it references Code of Civil Procedure, sections 1209, 1211, 1211.5, and 2015.5. So what you should do is you should take a look at those statutes, and you will see the law that pertains to contempt of court. So let's go ahead and go there. Let me share that part of it. Okay, you should see it now. Actually, let me just back up how you find this. If you go to the leginfo or leginfo.legislature.ca.gov, go to Code of Civil Procedure, and go to the section right here of Special Proceedings, and you're going to scroll down and go to this Title 5 of Contempts. And right here is where you're going to find all the law that relates to contempt of court. And if you scroll down to 1211, you'll see that it talks about how a judge can issue a contempt finding. But 1209, Section 5, it says disobedience of any unlawful judgment, order, or process of the court is something that constitutes contempt of court. Now, how do you prove it? How do you prove that your ex is in contempt of court? What I want you to do is do a Google search for CALCRIM, C-A-L-C-R-I-M. And what is CALCRIM? CALCRIM is an acronym. It stands for the California Criminal Jury Instructions. The jury instructions are a summary of all the appellate cases that have addressed any particular issue when it comes to criminal jurisprudence in California. So it's just a summary of all the case law where the judges have interpreted certain statutes. And if you look at CALCRIM 2700, which I'll share my screen real quick here. CALCRIM 2700 and 2701, those are the jury instructions that relate to contempt of court. And this website does a real good job of having the jury instructions on here, Justia. But this is jury instruction 2700, violation of a court order. And it shows here are the 4 elements that you must prove to for your ex to have been found guilty of contempt of court. There must be a lawfully issued order that the defendant do something, allow you to have FaceTime every day at 6:30 p.m. The defendant, meaning the ex, knew about the court order, and the defendant had the ability to follow the order, and the defendant willfully violated the court order. In the Code of Civil Procedure that we just looked at, one of those code sections says that if the party in family court has been served the order, then that is proof that the party knew about the order. And so you'll want to present that the party was served. You can do that by sharing the proof of service. And then the question is, did the party have the ability to comply with the order? And did the party willfully choose not to follow it, to willfully violate the order? So did your ex have the ability to pull you up on FaceTime at 6:30 p.m. with your 4-year-old daughter? I don't know. You'll have to present evidence that your ex did have that ability. And did she willfully violate that order? I don't know. You're going to have to come up with the evidence that she essentially chose not to do it for whatever reason, because they were late with dinner, or they were at a movie, or she was in getting ready for bed, or who knows what the reason is. But these are the types of evidence that you're going to want to present. Last thing is the California courts have real good resources on this. What I'll do is I'll put a link in the notes at the bottom of the video. When I'm done, I'll put a link to a PowerPoint presentation, or at least the printout or the notes of a PowerPoint presentation that the courts have on their website. Or you can find it yourself if you Google something about contempt in court. But I'll put a link to it. And that should give you a good idea of whether or not your ex was in contempt of court. I can't answer the question because I don't know the details of your situation. But hopefully you will be able to answer that question. Okay, I hope that was helpful. Let's see, we have a comment here. So I charged my ex with 16 counts of contempt. She also perjured herself in court, and the judge acknowledged she lied. Great. Can I file contempt through perjury, or what motion can I file to address perjury? Contempt is a violation of a court order. So perjury wouldn't be the contempt. It looks like you already filed the counts of contempt. The perjury itself, I wouldn't think would be the perjury. It's the contempt is when she didn't allow you to get on FaceTime, or didn't allow you to exercise visitation, or whatever it is. But can I file contempt through perjury? What motion can I file to address perjury? One of the things that you'll notice in the Code of Civil Procedure, if you read through those sections that I just showed you, 1209, etc., one of those code sections says that a party who is in contempt of court cannot move the court to enforce the order. In other words, if a party has dirty hands, unclean hands, they say, is in violation of the order, the party is not in a good position to try to force the other party to follow the order. So if she's in contempt, she can't come back to you and say, hey, or come back to the judge and say, hey, he needs to follow the order. The judge isn't going to listen to it. And the reason why I brought that up is she can't do anything to you. She can't do anything to you when she's in contempt of court. So I'm not exactly sure what it is you want to do, or what it is you want to fight when it comes to this perjury. You say, is there a motion you can file to address the perjury? Well, what is it that you want to do? I'm not really sure. Perjury is a crime. And so what you can do is you can go to the police, you can go to law enforcement and see if they will enforce the criminal laws against perjury, and see if they're willing to act on it. Very often they're not. Like almost never are they willing to do that. But you can try, and you can go to the prosecutors, the district attorney's office. But what is it that you want to accomplish, and you think that the perjury is going to help you? If you want to gain more time with your child, if you want full legal custody, can you bring up the perjury? Sure. But the motion that you would file isn't really a motion about perjury. It's a motion to get more custody. And then the perjury would just be something that you would add on top of it. So I hope that answered your question. Someone says here, I have a family law contempt hearing in 2 weeks. My attorney told me that is only the arraignment and not the actual hearing. He said she will enter her plea only. Hearing will be in future. Yeah. So, good question. When a contempt action is quasi-criminal, which means that it could subject the perpetrator to jail time if the perpetrator is in fact found guilty of contempt. And when it comes to criminal cases, the Constitution is very has puts limits on government action, and because you're bringing this action as a private citizen on your action, someone who is accused of committing a crime has a right to notice of what they're being accused of doing, the crime they're accused of committing, and certain due process protections. Anyway, so once you file this contempt action, the very first hearing is going to be an arraignment. An arraignment is the hearing where the accused has an opportunity to be told what it is she is being accused of doing, what crime she's accused of committing, and then she has an opportunity to either plead guilty or not guilty. She could plead guilty. For all you know, she might plead guilty. And in that situation, if she pleads guilty, you wouldn't need to have a trial because she's admitting it, right? So if she pleads not guilty, then that's when the court would say, okay, well, let's set a trial, an evidentiary trial where you're going to present your evidence. She might present her evidence. But before going to trial, she needs to have an opportunity to enter a plea, to say, I'm not guilty of this, or I am guilty of this. And so that's what your attorney is talking about, is that opportunity for her to enter a plea. I hope that helped and answered that question. What is the realistic outcome for 16 counts of perjury? My case is ironclad, and her attorney has reached out to try to make a deal with her admitting fault to some. Will she actually go to jail? Two questions there. What is the realistic outcome? I don't know. I don't know how long a period of time these 16 acts of contempt took place in. If it was 16 counts of contempt in a space of 1 day, 2 days, 3 months. I don't know how many warnings the judge has given her in the past. If he's told her 3 times in the past, you better watch it because I'm going to, if you don't follow my order, I could find you in contempt. So these things are going to be a factor here. And then whether she goes to jail, let's separate these two things. One is she guilty of contempt? And then the second question is, okay, if she's found guilty of contempt, what is the sentence going to be? What is her punishment going to be? And so those are two different things. She could be found guilty of contempt on 16 counts, and she could potentially not go to jail, or she could go to jail. And let's say she's ordered to go to jail, to be remanded into custody. How long would it be? I have no idea. It's just going to be up to the judge. She's certainly going to have some arguments about why she should not be in jail. Maybe she has a job. maybe going to jail would actually be detrimental to your child or children. So that's going to be a very case-specific situation. Some things that you're going to want to be thinking about is, has she ever served jail time in the past, especially for contempt? And does she have the ability to, can the judge sort of convince her to not, can the judge convince her to follow court orders without sending her to jail? Is there some other lesser punishment that she could be sentenced to, such as fines? Can the judge sentence her to jail but not actually enforce the sentence? So could the judge say, look, I'm going to sentence you to jail for 5 days or whatever it is, but I'm not going to actually impose the sentence right now. I'm going to give you one other chance. And if there's one other screw up, I'm telling you now, the sentence will be imposed without any hesitation, without any other chances. That's another possibility. So you're really going to want to talk to your lawyer and see if your lawyer knows that particular judge, and that will give you a better idea as to what that judge's temperament is and how the judge is likely to treat your ex. Yeah, and so contempt, 16 counts of contempt over 2 weeks. In my experience, 2 weeks is not a whole lot of time, but I don't know how that will play out in your court and in your case. Yeah, you're welcome. When it comes to these criminal actions, these contempt actions, for criminal cases, once guilt is found, the next question is sentencing, like I said, and a defendant who is found guilty can ask that the sentencing hearing be postponed. So if you have your arraignment where she's going to plead not guilty, let's say, you put out the trial for a couple months or whenever it is, and you have a trial where evidence is presented and people testify, and the judge comes out with a ruling saying, I find her guilty of contempt, 16 counts of contempt. The judge could impose sentence at that time, could issue the sentence at that time, or perhaps more likely the judge could say, okay, now let's talk about sentencing, but I'm going to push out a sentencing hearing for a later time. And you could have a third court appearance for the sentencing hearing. Prior to the sentencing hearing, the parties can potentially, in your case, draft and file some briefs called a sentencing memorandum, where you're talking about what should the sentence be. And so you could file a brief in aggravation saying, here are all the aggravating factors, Your Honor. Here's all the evidence that suggests that you should not be lenient with her, that you should impose jail time if that's what you want. If not only if that's what you want, but if that's what's in your child's best interest as well, I would include that. And so you might list these aggravating factors that would suggest that the sentence is higher. She might file a brief in mitigation, it's called a mitigating brief, where she's saying, well, here's all the evidence, here are all the different factors that suggest that my sentence should be lower, that suggest that my sentence should just be a fine and not jail time, something like that, or maybe anger management classes, or maybe a parenting class. So these are the things that will be addressed that will determine what the sentence is. Then, of course, the judge will read all of that and make a decision about what to do. Okay, you're welcome. I hope that helps. Is it possible to change custody? All right, let me take off this banner. Okay. Is it possible to change custody during a contempt hearing? Maybe judge finds the respondent to be in serious violations. It depends on what's been filed. So when in a contempt hearing, you're going to file just a normal motion, and you could at the same time file a motion for a change of custody. And so, yeah, you might want those filed at the same time. Another attorney I was talking to said, and we have a video on this, said you probably would not want to do that, file two different motions, one on contempt, one on change of custody. But let's say your ex is sentenced to jail time. And let's say that jail time is during a period of time when she would have custody of your child. Well, then, yeah, the judge will have to make orders changing custody at least for those 5 days she's in jail, something like that. So yeah, there would be at least there could be at least temporary orders, custody orders, and that would likely be addressed at the sentencing hearing. But if you're talking about permanent changes in custody, you're going to have to file a motion for that. The judge probably isn't going to address any issues that have not been noticed, that she wouldn't be already on notice that it's something that's an issue that's going to be litigated, which is the whole point of the RFO documents, the request for order documents, is to provide notice. Yeah, and so when you ask about the serious violations, does that make a difference? Does it make a difference if the violation is serious or not? I don't know what. I don't know that the judge can. When it comes to the notice of custody, litigating custody issues, the seriousness of the violation, I'm not sure if that plays a role. It certainly will play a role in the sentencing, which could impact custody, of course. Okay, that's all the questions that we have. I hope that was helpful. Once again, I think you should go to My Court Coach, check it out. We have a lot of videos here on YouTube, but what we don't have are all the other resources that you can download on the website, templates, checklists, guides, things like that. I highly recommend, if you don't have a lawyer, to get the full court preps, so that if you are litigating a contempt action, you will need to be able to present your evidence and your testimony and your arguments. In order to do that, you're going to want to know the rules of presenting an exhibit, how to make an objection, how to respond to an objection, how to make a convincing closing argument. Notice that the phrase is closing argument, not closing statement. You can get help with all of this in the full court preps, which is available at My Court Coach. You're welcome, Andrew. Lastly, if you think this is helpful, maybe you'd be willing to tell your friends and family members about My Court Coach, about our live streams, and recommend that they check it out. Okay, that's it for now. I hope you have a good night. Stay tuned for the next one. Take care.